Hello and welcome. My name is Caitlin Works Figueroa, and I'm reporting to you from the armchair of Case Law tonight, where we examine case law as it applies to top issues faced by public administrators. This segment will cover the Supreme Court case of Chevron v. the Natural Resources Defense Council, which is commonly referred to simply as Chevron. Just over 34 years ago, this case was decided with a unanimous vote of 6-0, with 3 judges recusing themselves. While this outcome was not reviewed as a landmark decision at the time, today I will discuss the significance of this case in terms of legal, political, social, and economic implications. I will also address the overall impact that the Chevron case has had on public administrators. To begin, let's consider the legal implications. These are clearly recognizable in the 34-year aftermath of the Chevron case. The Supreme Court set a precedent known as Chevron deference, which provides 3 main guidelines for consideration when judicial review of an agency statute is necessary. These guidelines are covered by Professor Rosenblum of American University as being, quote, widely applied to statutory interpretation. In essence, Professor Rosenblum explains that either Congress defines the terms in question, or public administrators are left to determine their meaning, which some may argue leaves administrators to implement their own interpretation of the law, giving them power not intended by the U.S. Constitution. Administrative deference is given so long as the definition is reasonable and permissible based on the legal text. Therefore, the courts are not allowed to apply their own interpretation of the law in these situations. They simply review the agency statutes as adhering to these standards or not. This Chevron deference has been a guiding doctrine used in cases at all levels of the judicial system since the Chevron case was decided. This can sometimes be contentious. Now to address the political significance, namely, the divide which exists between those who favor a bigger government and a bigger machine and those who wish to see regulations scaled back dramatically, while public administrators are bound in proverbial red tape. This debate is now reaching an elevated level of significance due to the opinions of our most recently confirmed Supreme Court Justice. Ballotpedia remarks that, quote, Neil Gorsuch has been critical of Chevron deference and has been held up by the current administration as a model for judicial appointments. Ballotpedia also explains that, quote, the Trump administration is devoted to a legal doctrine that challenges the broad power federal agencies have to interpret laws and enforce regulations. In 2016, the Trump campaign made numerous appeals to the public for their support regarding a policy platform to decrease regulations. Many regulations currently held under harsh scrutiny by the Trump administration include environmental protections, which were originally implemented by the Obama administration under the safeguard of Chevron deference. The Trump administration believes broadly that regulations are hindering businesses' ability to hire and retain workers due to profit loss. These regulations stem directly from definitions that agencies develop based off of laws handed to them by Congress. With this policy priority of opposition to the Chevron deference now at the helm of the executive branch, the Chevron decision is growing in terms of political significance. I ask our viewers, What do current and future public administrators think about this? Is it better to allow the court to provide final guidance regarding enforceable definitions inherent in legislation, which impact and guide administrative statutes? Moving forward, we will look at social implications. Social significance, in a sense, less directly lies in the current air quality standards we experience as a society. Additionally, the social significance can arguably be seen in varying standards we enjoy in our food, water, prescription drugs, and countless other areas. Standards which are upheld by regulations put in place by administrators who acted based on their freedom to determine statute definitions and the aftermath of the Chevron ruling. We must keep in mind, however, that these societal implications are not easily quantifiable. This is because we cannot look into what may have become of industry standards, or what may have been enforceable regulations if the Supreme Court chose to uphold the judgment of the Court of Appeals, in this case 34 years ago. It is worth noting that in his analysis of the case for the Columbia Law Review, J.D. Philip Warren made the following connection, quote, "The EPA issued its endangerment finding under the Clean Air Act, which determined that greenhouse gases may reasonably be anticipated to endanger public health or welfare. If this is accurate, as well as other claims by the EPA, it could be argued that the Chevron ruling acted inadvertently to prevent such endangerment. Additionally, we may consider that attitudes towards the actions of public administrators and their ability to implement statutory definitions based on their findings has a societal impact in the form of relationships between public administrators and members of the public who either A, rejoice in their administrative protections, or B, curse this perceived administrative overreach, thus creating cultural and societal attitudes towards those who serve the public. I ask the audience, can some of the positive societal impacts be downplayed by the individual economic implications of more expensive goods? In considering this question, let us examine another significant but also inadvertent implication of the Chevron ruling. That is, the economic impact on companies, and perhaps entire industries, which have been impacted by judicial deference to agency interpretation. It would not be impossible, or perhaps even difficult, to argue that results of Chevron deference have included the loss of court cases, the loss of revenue, and more stringent regulations than may have been directly stipulated by legislators or judges. Unfortunately, this significance is likely immeasurable. However, we can consider an excerpt from the opinion of the court for the Chevron case, authored by Justice Stevens. He stated that the, quote, plant-wide definition is fully consistent with policy concerns regarding the allowance of reasonable economic growth. Therefore, we may assume, or at least hope, that reasonable economic growth for the company in question has been a point of consideration for judges in subsequent decisions as well. Although this specific point may have been lost on other judges, leading to what some may consider unfair regulations for industries due to harsh administrative interpretations of the law. Some additional questions for the audience to consider. Should administrators be given the leeway to interpret law in general, even in the context of definitions? Further, are regulations unfair for businesses? And should the answer to the question of fairness for industry even matter given the potential positive impact experienced by society? We are now led to a more in-depth analysis of what this means for public administrators in general. It has been established that administrators are given more free rein to decide what law is communicating. In an article published by the National Resources Defense Council website in 2015, Brian Palmer writes, quote, "Chevron deference merely strengthens the executive branch at the expense of the judicial branch," noting that, quote, "In the 3 years following the decision, the administrator's win rate in constitutional challenges rose by 10 percentage points. This is not insignificant. We could argue that public administrators received the ability to decide what law should do based on their ability to prescribe definitive structure to legislative intent in the form of definitions for regulatory statutes. Furthermore, in a report for Notre Dame News, Shannon Roddle quotes Notre Dame law professor Jeffrey Pohanowski as offering the following comment on the Chevron case. Quote, "What is most important is its systemic effects. By giving agencies a heavy benefit of the doubt where the law is unclear, Chevron gives those agencies more flexibility to regulate according to their policy preferences. Thus, Professor Pohanowski acts to solidify the argument that public administrators take greater power from the Chevron ruling than they readily held beforehand to implement statutes based on vague, indeterminative laws. Do administrators deserve this benefit of the doubt, or should they simply implement what is handed to them by legislators and rely on the court's interpretation of vague language? Should administrators even attempt to implement policy that does not provide clear guidance, or are they wasting taxpayer funds and attempting to carry out their own ideas, which could later be overruled by judges if the Chevron deference did not exist? Or is it important to have this Chevron deference and to allow administrators to make these judgment calls? Because, as was pointed out in the opinion of the court for this case, administrators can often be seen as the subject matter experts. In closing, I would like us to consider the stated agenda of the current administration. How would changes to the 34-year-old Chevron ruling or the slow chipping away of Chevron deference impact public administrators? Given what has been covered tonight, how would the wearing away of the Chevron deference alter the current significance that the Chevron ruling has long imposed on the areas of law, politics, society, and economy? Consider that in a concurring opinion for the United States Court of Appeals 10th Circuit, now Supreme Court Justice Neil Gorsuch referred to Chevron as a, quote, Goliath of modern administrative law, and further outlined his belief that if Chevron were to, quote, fall, the courts would then fulfill their duty to exercise their independent judgment about what the law is. I ask, is this an opinion that should be concerning for public administrators, or should public administrators share this opinion? And should the Chevron ruling remain intact and allow administrators to fill in the gaps left open by vague legislative language. I hope that you have taken away some of the most significant areas of impact in the aftermath of the Supreme Court case Chevron v. the Natural Resources Defense Council. Signing off for Case Law Tonight, I'm Caitlin Works Figueroa. Thank you for joining us.